So and if you're interested in getting leave, where do you get leave? I mean, sorry, if you're interested in getting stay, where do you get stay?
It's still a stay can be sought in the High Court.
So you file your judicial review application and you also file another one seeking leave?
No. You file an application for judicial review and seek a stay.
And seek a stay?
Yes.
You have an idea, but when you file an application seeking leave and you're granted, it operates as a stay. What about in an appeal?
In an appeal, you can seek a stay from the court that originally determined the matter, or you can seek a stay in the appellate court by your filing an application.
What remedies do you seek in a JR?
You'd seek remedies either to quash the decision of an administrative body.
So you're seeking an order for certiorari to quash. What else?
You can also seek an order of mandamus.
Yes, an order for mandamus. Finally? That one has skipped my... You can seek for an order of prohibition.
Yes.
What about in an appeal?
In an appeal, you can seek to set aside the judgment of the lower court.
And if you're not dissatisfied with part of the judgment, you're okay with part of the judgment?
Then to the extent which you are dissatisfied, you can seek orders to that effect.
All right. Thank you. That's all, Honorable CJ. Thank you, Honorable Chair. Good afternoon once again, Your Honor.
Good afternoon, Honorable Commissioner.
If you need, you can take water.
Yes, I should.
Yes. Okay, thank you. I've gone through your sample writings. You submitted your thesis paper and decisions in civil matters. However, the most recent sample writing is of 2018. So maybe you can explain to us why you chose to submit to us not recent publications.
Thank you, Honorable Commissioner. I did not sit again once I was appointed as registrar, so I have not been in court to hear matters since I became registrar. So that is the earliest I could.
So you don't do reports, you don't do memoranda, and any other?
I do.
You don't do any writings?
I do a lot of writings, but they look more internal documents, or those which we write to stakeholders, board papers or concept papers. So I thought those were more of institutional documents.
Okay, which you can as well get consent to submit them, so
Sorry?
that we know. You can as well get consent from your supervisor, so that you then submit to us, because it would be good for you to have shared very recent writings.
I agree, only that I had thought that my own writings would suffice.
Okay, so that said, you are able to identify issues clearly and apply legal principles in diverse subject areas. Your writings are coherent and the tone is professional. But I also took note that in the 4 sample writings, you did not make any reference to precedent. How will we tell that the final orders or your analysis was based on set legal principles or established legal principles and not just your own personal views?
Honorable Chief Justice, Honorable Commissioner, I have made reference to jurisprudence in one of the cases. I think Martin Jalale.
Proceed. Yeah, proceed.
Yeah. The only reason why I picked, especially that one of Caroline Nasimiu, is because my reasoning was tested in the High Court and also in the Court of Appeal. So I had wanted to demonstrate to the Commission that my writings have been tested in the higher courts, and that's why I picked those authorities, just to demonstrate that they have been tested by the superior courts.
Okay, I'll have to review them further because I didn't see any.
And I've also brought the High Court decision and that of the Court of Appeal
that affirmed your decisions.
That affirmed the decisions.
Okay. So your academic paper you wrote on judicial performance management, and among your recommendations were there is need to introduce qualitative parameters, and there was need to enhance stakeholder integration to improve accountability and service delivery. Has that changed? Because since you wrote your paper 2018 to now, there are so many things that have happened to improve the performance of judges and magistrates.
Yes, yes.
Including whether we've integrated stakeholder feedback.
Yes, that has changed in terms of stakeholder engagement. The only bit that we're still struggling with is the qualitative aspect of gauging performance. We still do not have the parameters to look into the quality of the work, except perhaps where judgments are appealed. So you look at what the superior courts are saying and maybe form a trend and see whether judgments of a particular judicial officer are quality based on maybe the rate at which they are overturned or upheld in the superior courts. So far, we haven't gone that route. And I was making that recommendation based on what happens in other jurisdictions. I had referred to the system in Australia and also in New Jersey, where qualitative work of a judicial officer is measured through stakeholder engagement, where stakeholders are asked to comment about, let's say, a judge's temperament, and questionnaires are filled, and then the team that is doing performance will be able to take into account what people are saying about a particular judge, in addition to the quantitative aspect of the work of a judge. So we haven't really gone that route. Probably the team handling performance may want to consider how we can now also look at quality of the work instead of just numbers.
Okay. It is said that the Judicial Service Commission often responds to pressure for speed and efficient delivery of services by increasing the number of judges and judicial officers. And on the other hand, the judiciary would then come up with rules and procedural layers, and also setting up committees to address the issue. Does increasing number of judges necessarily improve judicial efficiency? And could you give further details to your response? And what needs to be done to improve efficiency now that you sit as a registrar?
Thank you, Commissioner. The issue of numbers has been there before, but it's not the only reason why that can improve on efficiency. But of course, we have had lower numbers in all cadres, judges, judicial officers, and staff, and we need the numbers for purposes of performing the work. But it is not the only reason, because once the work is done, then of course there'll be numbers, but without really work. So I think if we are to improve on our work methods, to make use of the resources that we have, in terms of case management, in terms of putting more hours for purposes of working and improving our operational efficiencies, then we should be able to handle the work. It is not numbers, because you may also have numbers, and then again the work does not move. So numbers alone will not guarantee that there will be efficiency. So it's all about using our resources like case management, ICT, in terms of improving our efficiencies, and then that way you can say that numbers may not be the only consideration.
Okay. Lastly, you say you come from Narok, and I know parts of Narok are under the Community Land Act and other parts of the country. Can a person lay a claim of matrimonial property in a community land setup? If yes, if no, give reasons to your question, to your answer.
You asked whether a person can lay
claim of matrimonial property in a community land.
No.
Okay, thank you. Thank you, Chairperson.
Thank you, Chair. Good afternoon once again, Mheshimiwa.
Good afternoon.
Now, picking still on the question of case management, why do we do pre-trials?
We do pre-trials to ensure that we sort out preliminary issues before the matter comes for hearing, so that by the time the matter comes for hearing, there will be no room for adjournments, because we'll have sorted out many of the issues, like, for instance, the agreed issues. You can also have parties look at the issues and see what is contested, what is not contested, for purposes of maybe referral to DR, and also to exchange documents and agree on what need to be produced, just to ensure that by the time the matter is fixed for hearing, there'll be less adjournments.
Okay, you mentioned ADR. What forms of ADR do you know?
ADR, we have conciliation, we have mediation and arbitration, and other traditional justice resolution mechanisms.
Okay, what is the main difference between mediation and arbitration as modes of ADR?
Mediation normally involves a neutral party bringing parties together so that they can be able to agree on actually, so the solution to the problem would be coming from the parties. So you just need a mediator to bring them together and give them an environment to be able to agree. But on arbitration, the parties would agree to allow an arbitrator to arbitrate on the dispute, and the decision of the arbitrator is the one that's going to be in use. The parties will not be part of the decision. They'll just present their case, and the mediator separately write an award.
Okay. So suppose you are carrying out a pretrial in a succession case. One of the reasons why we do pretrial also is to dispense with interlocutory matters. So in the course of a succession case, there's an application before you for a grant ad colligenda bona. And in the supporting affidavit, they are saying the deceased left behind children, and we need school fees. The children have been thrown out of school, there's money in the bank account, and we want a grant ad colligenda bona to access the money to pay fees. Would you grant that order?
Yes, I would grant, just for that purpose of withdrawing monies to pay school fees.
When do we give a grant ad colligenda bona? For what purpose do we give a grant ad colligenda bona?
I think for purposes of collecting and preserving the estate.
So if you utilize part of the estate, is that collecting and preserving?
Well, that I may have missed that one.
Yes.
Yes.
Yes. So for grant ad colligenda bona, you do not utilize or dispense with whatever is in the estate. Okay. Looking at your performance, I don't know if you've seen your performance report from DISPO.
I haven't seen it.
I just want to say here that what you've said about yourself in the introductory statements is quite true. The report we have here from DISPOP is that 2021, 22, 22, 23, 23, 24, you've maintained consistency in terms of getting a score of 100%, which is very good performance, and that is quite commendable, and that this has gone on for the last 5 years. So I commend you for that, and I wish you well. Thank you, my lady.
Thank you very much, Honorable Chair, and welcome again, Mheshimiwa.
Thank you.
So, you've been more on administrative duties, eh?
Yes.
Could you tell us how you will reconcile the right to a fair hearing with the need to dispose of cases expeditiously with limited resources?
Maybe you can come up again.
The right to fair hearing, could you tell us, or could you reconcile the right to a fair hearing with the need to dispose cases expeditiously, considering that you have limited resources? How do you organize your matters?
Thank you, Honorable Commissioner, for that question. I think